Thank you, Mr. Chairman. I have a habit not to never correct Mr. Chairman, but some of the correction will be in the slides. Okay? So, Jewish law, medical ethics, and regulator. I was for almost 10 years the chief officer of medical ethics at the Ministry of Health until I retired. And I want to share with you some of our experience, and I'll try to find at least one point, which is a very unique point in one of our medical ethics law, which I don't think that it consists in any other legal system in the world. We'll see it soon. See, the Chief Officer of Medical Ethics in the Ministry of Health, and the mandate of Chief Officer of Medical Ethics is to deal with several ethical medical issues, and some of them I listed here: assisted reproduction technology, ovum donation, surrogate motherhood, cloning and stem cell therapy, the dying patient, definition of death, the patient's rights, and animal experimentation. Almost all of these points were not ended, but we created special law which deals with the main ethical issues of these topics. For example, assisted reproduction technology, we're dealing with ovum donation, surrogate motherhood. What's the difference between surrogate motherhood and ovum donation? It's very similar. What's the real difference? Who is going to be the social mother? In both cases, what we did, we divided the functions of the mother between two mothers. One of them is genetic mother, one of them is gestational mother, physiological mother who gives birth. It's true in ovum donation, it's true in surrogate motherhood. The only difference is who is going to be the social mother. In ovum donation, the mother who gives birth is going to be the mother, while in surrogate motherhood, the genetic mother is going to get the child and to grow him into be the social mother. We're dealing with PGD. We can use it for medical purposes, for example, to avoid X-linked disease, to let only girls be born from the ART, from the test tube baby. And we do it for social reason. I have only 5 boys and I want a girl. May I use a PGD to make a girl? I'm not asking the opposite, because I found out that I get different answers. We're doing about cloning. Cloning, we can do it as a reproductive cloning, and we can do it as therapeutic cloning. And I can't forget that over 10 years ago, there were a lot of discussions in United Nations. And our view was that we are against reproductive cloning, but we are for therapeutic cloning. We can help some human being to be more healthy. Why not? But on those days, the President of the United States then was following the Catholic point of view, and the American forced us to vote against therapeutic cloning. Nobody will tell you, nobody will teach you, but that was the case. So I'm not going to tell you who was the president, but it didn't change the results of that vote. So let's talk about some of the bills, of the laws. We have ovum donation law, 210. It's a law that in the Ministry of Health we worked on it for about 10 years. And already we have such a law. We have a law of surrogate motherhood. It has a different name. The law which deals with agreements to carry a fetus. So the law deals with the agreements, and there is a special statutory committee which check every agreement about surrogacy, and they check if it's ethical or not. I worked for more than 10 years in that committee. The dying patient. The dying patient law was created on the end of 2005, and it started to be effective on the end of 2006. And this is the law which tells us when a physician is not obligated to elongate life for somebody who is already called dying patient. Okay, what is dying patient? Any definition? Somebody who's going to die, so I am a dying patient from birth. So what could be a dying patient? Somebody who's going to die today?
According to the law?
You know the law, so I'm not asking somebody who knows the law. I'm asking somebody who doesn't know the law. What would you suggest to put in the law? What is considered as a dying patient? In the world, there are two definitions. Somebody that even if he's going to get treatment is not going to live more than 3 months. And other definition, somebody that even with treatment is not going to survive more than 6 months. The Israeli Knesset chose the second option. So dying patient is somebody that an expert physician writes in the chart that even if he's going to get the full treatment, he's not going to survive more than 6 months. So for such a patient, there are cases that you are not obligated to elongate his life or his suffering. Of course, he has to suffer for that, because otherwise, why not? He has to want. It's going to be not informed consent. It's going to be his will. He's begging not to elongate his life. You have to be sure, beyond any doubt, that it's really what he wants. These are the three major points which has to be cleared before a physician can get a permission not to elongate life. There are more details. There is over 50 paragraphs in that law. But first of all, you have to know what are the three definitions, or this may be his status as a dying patient who doesn't want to live for sure and who's suffering. The patient rights. The patient rights law was created in the middle of the 90s. And it has very interesting paragraphs in there that every patient has the right to get health. Now, if he has, what about payment? Somebody who does have money to pay has a right to all medical treatment. In case of emergency, everybody has the right, even if he has not a penny on his body and on his bank. and in his bank. Okay? This only in an emergency. This is part of the patient's rights law. But we're doing with legislation, statutory committees, achievement, and I'm trying to go over with you on one of the very unique paragraphs of the Israeli law, which is a really unique paragraph. Paragraph number 15A deals with the principle that you're not allowed to give anybody medical treatment without informed consent. Very simple. The exceptions are in 15B and 15C. 15C, it's very simple. In case of immediate emergency, somebody who was passing a train cut his distal part of his arm, he's bleeding. If you're not going to close the bleeding, he's going to die within 3 minutes. And he says, don't save me, don't save me. In case of emergency, immediate emergency, you don't need informed consent. That's paragraph 15C. Paragraph 15B is dealing with something between regular cases and emergency. It's called severe danger. In Hebrew, sakana chamura, same thing. Which means that he might die or lose part of his body if he's not going to get treatment, not right away, but within a few hours, maybe 2 or 3 days, sometimes 7 days. For example, the son of my neighbors is one of the best athletes in Israel. He's a soccer player. His soccer is all his life. After a car accident, gangrene developed in his left leg. And he came out. We have 2 choices: to do a lower amputation surgery, or if we're not going to do it, he's going to die. Not 100%, 90%. And he's shouting, without soccer, my life are unworthy. Don't treat me. I don't want amputation. I prefer to die. We called a psychiatrist. He said he's normal. This is exactly what he feels now. But a social worker told us that she has a great experience in such cases. She had many cases like that. He wants to die. He was forced to be operated. And a year later, he was so happy that he was saved, that he came to the doctor who treated him without informed consent. He gave him a very nice present. We can understand it. It doesn't mean that he's not normal before the operation. This is what he feels before the operation. But we have enough information to think that later we will have what the law calls retroactive informed consent. So is retroactive informed consent enough to operate him against his will or not? What do you think? No. Let him die even though you know that if you're going to operate him, he will say, thanks for not listening to me. I told you, if you know, or you can...
You have foresight.
I know, you have foresight from experience. You have experience. If you have experience, and you can say that probably 90% will be, if I think that not, I know many cases that I was sure 90% that I'm not going to have informed consent. But what case if I do know that there is probability of 90% that I'm going to have retroactive informed consent? If not, I don't know if you heard that it was 20 years, it was 28 years ago, it was Mrs. Trabelski in Tveria. Over there, we knew that she's never going to give informed consent. Besides, it was very dangerous. We didn't force her, but somebody convinced her to have, and she died soon after the operation. But in such a case...
But the judge wrote in his decision that we cannot force it.
Of course, because in her case, it was before the law. But nevertheless, even after the law, this is exactly a case in which I don't have retroactive informed consent. I can be almost sure, maybe 95%, that I'm not going to have such a retroactive informed consent. But the case of the child of my neighbor, over 90%, in 2 years, will think he will go already to high tech. And the soccer, which already is something very important, sometimes soccer, sometimes it can be a girlfriend, which also we know that, even though right now he thinks that he's going to lose his girlfriend because of operation, if we think that he thinks that he might lose his girlfriend because of the operation, we know that after one girlfriend can come another. Okay? So maybe. Okay, maybe. But
how much do we take into account the amount of time?
as
What's the amount of time?
I don't know.
Let's say it's 10 years.
I don't know.
Let's say 50 years it'll be worse.
I would leave it to the ethics committee. It's a good question. I'm dealing right now with a principle, which will right now I found out that somebody is against the principle. But when he was trying to explain himself, he's not against the principle. He's against the evaluation of the situation which I brought here. He said it's a wrong evaluation. But you agree that if 95% that I'm going to get informed consent, still let him die, let my neighbor lose her child? Okay. So the Israeli law do not agree with you. Okay? And the Israeli law is unique in this case. And he says, not the physician. Ethics committee of the hospital should deal with it. And you need that the members of the ethics committee will all be almost sure, nothing you can be sure in this world except death, almost sure that in the future he's going to give informed consent. And I saw some of these cases. And some friends of mine from Be'er Sheva saw some of these cases. When they saw the law, they said, what a stupid law. How can you know? But after they saw all these cases, when the patient himself was so happy that he was treated against his will, because the ethics committee estimated that that's what's going to be. So it says, it was smarter than we were when we just saw the law. But you don't have to accept. This is the Israeli law. And we said the fact that somebody has a post of the psychiatrist that is normal, but is under certain type of mood that he doesn't want to give informed consent, we're not going to let him die. Okay, this is something unique, and I'm happy. I have to thank you that you gave me a contra, because usually when I speak about in Israel, everybody tells us, something so simple. How can you argue with it? So you did the job now. You show that it's something unique, and this is unique in the Israeli law. So thank you very, very much.